is intervening. But before that, I want us to make a step back and go 2 weeks back when in the reading list we had Vallenatos, okay? I mentioned that case last week when we were discussing whether non-discrimination is absolute or not. And I also asked you, some of you did it, few of you, to send me, the deadline was last Friday, to send me a note advising the government, the Greek government, what they should do in order to comply with this judgment. Okay. All of you who sent me this note will receive individual feedback, but I think it is interesting to discuss it here because it will allow us to see, I mean, at some point we can juxtapose it and compare it with the judgment, the opinion of the Inter-American Court of Human Rights that we discussed last week on migration and whether non-discrimination is jus cogens or not. But before that, it is also interesting because it will allow us to see the distinction between negative and positive obligations, and why, as I was telling you, this is so fundamental to make when analyzing human rights. Okay? So, anyone remembering the facts of that case?
The Greek government passed legislation.
They're still sleeping. Make them wake up. You can sing actually. Saying, the Greek government.
The Greek government
Like a rock star.
to allow civil partnerships for different sex couples only.
Okay, so
That was a breach.
the Greek government. Do you all know where Greece is? In this, yes? Everyone? Yes? Okay, I'm coming from there. Okay. So, Greece passed a law in 2008. So, the Greek parliament enacted a law which was saying what?
Only different sexes could enter civil partnerships.
It wasn't that brutal. It was not saying only different sex, but they were saying...
It was establishing civil unions, but it specified that, well, it says something like those couples from different sex.
Okay.
So it didn't say only, but it was like only make it.
Okay, so this was implicit, this was implied.
Yeah.
So what the Greek parliament did in 2008, they said, well, we have marriage, okay, wedding. This is one box. People who want to get married, they may follow that path. This has a number of legal consequences when you get married in terms of succession law, inheritance law, taxation, family rights, etc., etc. Okay, but if you don't want, you can go for a marriage which is like I call civil partnership like a diet coke. You don't get the full calories, you get half of it, okay, or 1 calorie. So you can go for civil union. They enacted, they created, they established a second box which has less weight. It has less legal implications, less legal consequences. And they said this box, this law, is an option for people of a different sex. Okay? What happened next in the case?
There were 6 couples. It was 6 couples or 3.
Okay,
I think it was
yeah.
3.
Different sex, same
Yeah.
sex.
Same sex.
Okay, so
Yeah.
6 couples of a same sex
Sorry.
approach the court, and
Yeah. They feel it. Oh, sorry, you're.
I have no idea.
okay, and
They feel injured by that law because it kind of limits their private life and their right to family life, and the non-discrimination principle contained in the European Convention on Human Rights.
okay. So for the latecomers, the Greek Parliament enacts in 2008 a law, and the law says from now on in Greece, instead of marriage, you can go for a civil union, civil partnership. This will be legally recognized and will produce certain legal effects. But they made this possible only for different sex couples, okay? And then you had some people, gay couples, that went before the European Court of Human Rights and said, just a moment, there is an issue here. Why? Because Article 8 of the European Convention provides the right to family, plus Article 14 of the European Convention of Human Rights prohibits discrimination on the basis, on a number of bases, including sex, race, religion, etc. Okay, so they said we are discriminated. Do you think this couple is discriminated? Those couples, they are discriminated? Hmm? Yes or no? We're discussing Vallanatos.
Okay.
Hmm? Is this coffee?
Yes.
That's a lot.
Can you circulate it around?
What do you say?
No?
So,
Okay.
is it the same sex that was discriminated against? Well, yeah, because they haven't got another avenue to achieve that kind of, to achieve a union in the law.
Okay, so one argument, yes, they are discriminated because there is no alternative to that. There is no, okay.
And also, the government was saying that they weren't discriminating them because they have a proper goal to protect children. So the idea of creating the civil union was not to protect like the couples, but to protect children born outside of marriage. However, it wasn't actually identified by the law and by the exposition of it. So the court said that it wasn't a proportional measure. So it was actually discrimination.
Okay, so the court applied proportionality, good point, I'll come back to that. Before that, I'm asking you, forget the law for a minute. Do you think that morally speaking this is discrimination? Yes? Yes? No? Why?
I don't know, just kind of feel because lots of Canada, they don't have, they married with same-sexual people, and they're going to improve that, but it doesn't mean like we have legislation, we have to make something like the same-sexual couple, we have to be get married, and we can improve that.
Okay, good point. The point here is, yes, you silly Europeans, you may think that you are strong in human rights and you want to dictate your standards to the rest of the world. Open your eyes. Most of the countries in this world, most of the societies think this is not discrimination. And they did not enact any law protecting or recognizing, giving legal effects to the union between two peoples of the same sex. What would you say on?
I think this approach is wrong because, okay, not many countries introduce like the same-sex marriage or same-sex union, but maybe it starts time we are in the 21st century and not in like whatever times. And if we don't start, for example, I don't know, if not Germany starts, not Poland, not Greece, then who will start that? Who will start like kind of the beginning of maybe customary law in the future?
There are thousands. So, this is a debate we will also have next week. One argument is what states are doing. The other argument is, yes, human rights, it's a question of values. We shouldn't take into account what states are doing. Let's change. We are in the 21st century. We need to change things, okay?
Also, my approach is that we can't, of course we have to take into consideration what other states are doing, but to be honest, we can't on every single thing, we can't look like, oh, Germany didn't do this, so maybe we should not also do this, you know what I mean? So it's like, because if one country is not going to start like something, like kind of like a wave of new human rights or whatever, no one's going to start.
Okay, other points? I can challenge that. I mean, I don't necessarily disagree with you. I will just challenge you in a way. Don't take it personally. I do it for educational purposes. Okay?
But wasn't the court saying? So it wasn't saying that. Oh, there's like a requirement to introduce civil unions. So wasn't it saying that? So basically, like if Greece had chosen to take no action, then there'd be no issue, and there'd be no civil unions, there'd be no gay marriage or anything like that. It was the fact that they chose to introduce an alternative type of union in the law, but then discriminating against. So I guess what I'm saying is there's not sort of a requirement under human rights law that there has to be civil unions for gay partners. It was the fact that they chose to introduce new legislation that was then discriminatory.
This is a key point. We will, I mean, both points, proportionality and what you just said, we will come back to them, but the argument here is that the European Court of Human Rights, he's telling you, did not do what you said. The European Court of Human Rights did not say we are in the 21st century, let's change things, let's make a step forward, etc. It does not ask Greece to provide gay marriage or same-sex partnership. What it does, we will see it in a minute. But let's go back to that debate. So we shouldn't take into account, or we should only take into account to a very limited extent what other countries and other societies are doing. Then we would rely on what to establish human rights?
Value. Value.
Sorry?
Value.
Values.
Values.
Okay. Values. Do you agree? It's a good point. Do you agree with values?
As a form of protection.
As the basis of what is right and what is wrong. So one argument here is, just to make it more concrete, this argument exists in the court's reasoning. Oops. Read this. Can you read it? Is it too small?
In addition.
While you find that, can make a point.
Sorry?
While you find that, can I say something?
I didn't understand.
While you're finding that, can I make a point?
Yeah, I'm going to make a point, yeah.
Can I make a point while you're finding it?
Yeah, sure.
There's a difference between, in Britain there's an argument, the difference between civil union and gay marriage was the fact that if they legalise or they authorise, if they have civil union participants have certain rights, then why aren't they transferred to common law man and wife? And so the argument was, yeah, legalise gay marriage but don't legalise civil union, because if you have civil union, it undermines the rights that the man and wife have when they're married. So it's a form of protection of the Marriage Act.
This could be an argument in the context of proportionality. This is not an argument that was made by the Greek government,
That's what I say.
but this is an argument that such an argument could be taken into account in the context of proportionality, into the mechanics of human rights protection. I'm not saying whether it is valid or not, but what I'm saying is that this is a reason that could be justifying, limiting a right, okay? So, can you please read this paragraph? It's a bit close to it. If I move, it feels lonely, and then it... What is the court doing here?
Comparing.
Sorry?
Comparing.
Comparing, yes? can I even summarize the argument here? You need more time to read.
You're basically saying that the majority of the member states of the Council of Europe now are heading towards accepting same-sex marriage or same-sex partnership, basically finding ways to give same-sex couples more rights in some form of marriage or partnership.
Mm-hmm. Yes. Any other interpretations?
But also the fact that a country in Europe found itself not in conformity with that sort of gradual evolution of introducing some form of partnership for same-sex partners didn't mean that it was in contravention to the convention at all, and that it didn't mean that it was sort of there was an obligation for it to enact legislation to protect registered partnerships of same-sex.
What the court is doing here, yes, it compares, and yes, it refers to evolution. It says, when they drafted the European Convention on Human Rights, it was the 50s. In the 50s, same-sex rights did not exist in the agenda, okay? If you would even mention it, in most of the countries, you would be in prison. But the society is changing, and we need to update the text of the convention, the way we understand human rights, on the basis of evolution, okay? To measure evolution, a method to encapsulate evolution is comparison. The court is not comparing, the practice of all courts, countries in this world. Why? Because this is a European court. An international court, a global court, would need to compare, across the globe. But now it says we have 47 states in Europe under the Council of Europe, signatories to the European Convention of Human Rights. And then the court is counting heads. Says, well, I'm counting how many states have a marriage. It's only 9, small number compared to this. But many states now have a civil partnership. Still, it is not enough to say that Europe has evolved, has changed to the extent of providing same-sex couples with the right to civil union. But if I see how many states provide civil union in their domestic legal system, I observe that only Greece and Lithuania, only those 2 countries, are not opening this also to same-sex couples. So, in reality, what it says is, yes, maybe you don't have the right, a duty, to establish civil union. But once you have established that civil union, all other states, apart from you, Greece and Lithuania, that have done this, they did it for both different sex and same-sex couples.
I think there was a court ruling in the UK recently where a different sex couple were not allowed to enter into a civil partnership. I think they lost.
Yes, it was very. I didn't read the judgment. I just saw this on.
BBC News.
Yes, something like that. And I had this in mind. We will discuss it in a while. So, a step back, and this is a question we'll discuss next week. Should human rights rely on evolution and state practice on the basis how to capture evolution? On the basis of state practice, should we, for human rights purposes, count heads? Or we should say, as you said, values. What would be the value behind this? Equality, a principle. If you were a judge, would you say, this is a matter of equality? I don't care what Lithuania is doing, I don't care what Latvia is doing, I don't care what Greece is doing, I don't care what Zimbabwe is doing. For me, it is a matter of equality. You cannot exclude people just because of their sex from certain human rights. Would you go with this approach, or you would go with the court's approach and you would say, well, I'm not sure. Gay, they're a bit strange. But by the way, let's see what states are doing. Which approach would you, what is the right way to interpret human rights for you?
The first way.
Hmm?
The first way.
First way.
With regard to this case, I'd say the rights of family life.
In general, let's discuss the principle. This is a case study. Should we often have questions about the existence of a right. Is there a right to euthanasia? One life begins. Is there a right of polygamy? Let me challenge you. No, you. I would tell you what challenge you. Okay. So you say this should not be a matter of comparison and evolution assessed on the basis of state practice. Would it be for you also a case of values? What would be the basis for?
I just said because I thought I don't know what I'd do if I was a judge, but for me, doing something. To be honest, even in the evolution way, even if looking at something what other countries do, it also sometimes doesn't work in many cases in modern world. For example, look at the death penalty and the United States. So many countries have abolished death penalty, especially in Europe, and they're still there and they're like, no, we don't care. We are still having death penalty, despite the fact that all the Western democracies, and US are the biggest one, and the all Western democracies abolished that. They're like, no, evolution.
This is a slightly different argument. Interesting, but slightly different. Why? Because here we need to make a step back. What you're discussing here is enforcement, compliance. But what we're discussing here is how a new human right is ascertained, how it comes into existence.
So,
Treaties, we'll discuss this in more detail next week. Treaties, human rights law is general, is abstract. Okay, on purpose. And then it goes back to judges and they interpret it. Should they interpret it following the pace, following the evolution given by states, or they should do it on the basis of their own values and principles? This is the question I'm asking. Just raise your hands. Values. Who says values? Values?
I don't think personal values.
yeah.
Values of whose values are?
I think it's really difficult to explain, but there's a point where you have to see what states are doing and you have to see what the trend is. Because like you say, in the 50s, same-sex rights barely existed, but then there was a trend in attitudes in people within states that there should be same-sex rights. And then those values are the values they should start. So it comes from states, but it's not necessarily entirely focusing on what
So you would be not the judge doing this ex cathedra, but following the evolution in the society, not necessarily states. Am I right?
Yeah.
Okay, you are with the people that the judge should not act ex cathedra, but should follow evolution in the society. Okay. The rest of you, anyone who says ex cathedra, judges should do it because they are good Christians, because they have, they are good Muslims. No?
They can't do it through their personal kind of, because everyone has like different
Okay.
morals, so
Okay.
they can approach them.
I was just say that I think that values probably are like part and parcel of it. I think that they will have decided we want to promote same-sex rights, and then they're just fitting the reasoning in perhaps what they think will be the least controversial way to get it through. So I think that they will have decided in their minds this is what we want to achieve because this is the progression we want to move human rights in. But they're just fitting the reasoning to it, as it were.
Can you imagine the same judgment being delivered by gay judges? Would they say, well, those straight people, they're a bit strange, but nevertheless, exactly the same, Probably not. Okay?
I don't think so. I think like when you are a judge, even though you're trying to separate your personal life and the law, sometimes it kind of involves both when you are actually creating a judgment. Like for example, I've read some articles that say like when a man is judging for a rape, he's gonna give less years compared to a woman who's gonna judge a rape. So I think it's the same thing.
There are statistics that have shown that judges who have a daughter, they tend to be more in favor of abortion, whereas judges who don't have a daughter, they are against it. This is an example of values, and how values influence. We will discuss all of these in much more detail next week, but this is an example of a morally sensitive area, okay? And you have that kind of dilemmas. How the law is made. We're discussing this in human rights. We're discussing this next week. Let me move to another question. I have plenty of points and questions to raise with regard to these, but we will discuss this next week. It is the topic we will discuss next week. So this was kind of opening your, giving you an introduction. Next question. The court, in that case, applied proportionality. So you have the same-sex couples who go before the court and say, well, we have been discriminated. Why? What happened to you? They established a law, and they said this law only applies to white people. Black people are excluded. It is the same. They made a law, and they said this applies only to straight people, gay people should not benefit from it. Okay. Why did the court apply proportionality? If you remember what we were discussing 3 weeks ago, I was telling you what is the reasoning, what are the steps that the judge should follow in human rights. First of all, is this protected by human rights? Yes, obviously, right to family, private life, plus discrimination. Has there been an interference? Yes, there has been an interference because they passed a law which says you benefit from the law, you do not benefit from the law. Should the court stop there and say, well, you do not benefit from the law, this is discriminatory, the law is against human rights, get rid of it? Or it should make the extra step and say, well, we made a law, you can benefit from the law, you cannot benefit from the law, but let's see, is it fine that you're excluded? Proportionality. Was this necessary? Are there reasons justifying this? Should the court do this step? Yes or no?
Yeah, they should definitely do this step because one of the rights that was interfered with was the right to a private or family life. And then under Article 8.2 of that right, it says that there shall be no interference with that right, except only by public authority, except when the national security is at stake or public order is at stake. So when Greece was interfering with the right to a private and family life, did it constitute sort of a threat, or if the right was exercised by same-sex partners, would it constitute a threat to public order or national security? Certainly no. So it didn't make sense for them to interfere with that enjoyment of that right by same-sex partners if it didn't qualify for the threats under Article 8.2 when they are allowed to interfere with it. So proportionality cannot be.
So proportionality?
So perhaps proportionality in the sense that if the enjoyment of that right by same-sex partners does not constitute a threat under Article 8.2, then there's no need for Greece to interfere with the enjoyment of that right by same-sex partners.
Any other ideas? And then I'll provoke you a bit. Any other ideas? Should the court apply proportionality? Proportionality, we discussed this in week 2, is the tool, the method that a court applies in order to assess whether a limitation to a right is permissible. Should we raise that question? Let me provoke you. Can I make a law that will say, well, white people sit from this side, black people sit from this side in my class? Is this discriminatory? Yeah. Is it? The Greek law, this is what it is doing. It says, we will have a law, but this will not be only open, only accessible to that social group. Okay?
Doesn't it depend on the intent?
Intention is irrelevant. What we are looking for is intention in my mind means something different. It means I do something on purpose.
Yeah.
Yes, when we enact a law, you always do it on purpose. But what is the rationale behind the law? And what I'm asking here is whether the court should get into the discussion of what was the rationale, or straightforward say, well, this is unacceptable. So, do you see any reasons that would justify black people sitting on the corner over there? Any reasons? Okay. Do you see any reasons why same-sex couples should be excluded from the right to have a legal recognition of their family? Then why did the court follow that path?
I think because there's a lot of people that still do think. There's a lot of people who just have that different opinion to what.
Okay, so it's again public opinion issue.
I think
Just to give you some thought for the next week. If human rights would be a matter of public opinion, and they would change on the basis of what public opinion wants, A, the majority would never give any rights to minorities. B, if the world would move to the wrong direction, as it does now, Trump, Marine Le Pen, Hungary, Poland, you see what is, I'm not mentioning Brexit, it's, if the world moves to the wrong direction, as it is happening now, then you will have a regression in human rights protection, because tomorrow the majority might say, you know something, women, they shouldn't be allowed to vote. Why to allow women to vote? 60 years ago, this, in many countries, this was not a right. So, would you follow proportionality here, yes or no? Just raise your hands.
yes.
Proportionality, yes. Okay, no proportionality? No one? No proportionality. Why?
I don't know.
Anyone who would not even discuss that there is a possibility to exclude same-sex people from civil union? Anyone?
Well, apart from the conflict of other laws that I said earlier.
Conflict of laws in what sense? Here there is a conflict of laws. You have the Greek
I
law.
know it transfers to EU law, but in British law, it could be a conflict.
This is in a sense a conflict of law. You mean conflicts of laws like transnational law?
No, conflict of domestic law.
There is no conflict of domestic law, but what we are discussing
In
here,
Britain, it would be.
there is a conflict between domestic law, Greek law, and the European Convention of Human Rights. The court, instead of saying straightforward, you know something, this is against the European Convention of Human Rights, it says, yes, it seems it is against the European Convention of Human Rights, let's see, Greece, if you have any good reasons why you should not comply.
Let me put it another way. I don't know if the British law, the domestic law in the UK, is actually effective if the EU law has its corresponding act, which is the protection of marriage.
EU law.
Yeah, I don't know if there's a similar thing in EU law. I mean, is the EU law, does that cover, is there any specific things in the EU law that protects
The
marriage?
Human Rights Charter.
No, but if you want to get a divorce, you have rights. You go to the court and you want to enforce certain rights.
But it's something similar here. Instead of EU, you have the European Convention.
But what that is, that's only applies to the same sex. There's when two people live together with the opposite sexes, they don't have the same rights as those that are married. Civil union is trying to have rights that are for them that aren't applicable to same sex. So there's the conflict. Do you understand?
No.
Okay. Right. If you're married, you have certain rights protected, right? And what I'm saying to you is that the same as in EU law? Okay.
It's not. No, it's not the same under EU law. It's let's say this is British law.
This is where it's. I don't understand it. But in domestic law, there is the Marriage Act. So if you want to get divorced, you have certain rights. Right? You can, 50% of the property, blah blah blah. If you're not married and you're living together for like 20 years and you separate, unless you contributed something, you don't have any rights to it. In the civil union, you do have rights. So what the complaint is, what the situation is, even though the civil union has certain rights, i.e. you can have 50% of the property, same-sex civil union, you have no rights.
But this differs from one country to another.
So the same-sex civil union, they want the rights that the civil union has. So that's why it's not.
No, this is not what they want. This is not what this case is about. Okay, this case is you in Greece. So in that particular country, you have marriage, a law about marriage. For many years, this was the only law. And in 2008, they made another law, and they said from now on you can choose either marriage. I don't know if it is 50% or what, you know, part of the property you take, but this is marriage. Or if you want, you can go for another box, for another legal regime, which gives you slightly different rights. But this was excluding gay people. And we have examined two questions. The first one is how do we establish that there is a right? And this is the moral dilemma between principles or values versus evolution, and how we capture this. State, practice, or public opinion, or whatever. This was the first question we examined. The second question we were examining is, the court says there is an interference. This is, it seems to me, the court says, this is incompatible with the European Convention on Human Rights. But instead of stopping short there, what it says is, okay, let's see if this is lawful, if this is allowed. And it applies proportionality. You all told me you would apply proportionality. You said no, but no justification. Any other arguments? Would you apply proportionality? Could the court, technically speaking, say, well, I don't apply proportionality? And if it would say, I don't apply proportionality, what would that mean?
That the right to non-discrimination is above the other rights.
Above or something more?
Or it's more important? Or
Yes.
just cogence?
Use cogence. Okay, so this is the right, any right, okay? If the right is absolute, it should always remain intact. It will always prevail over other rights. In terms of constitutional law, we call this absolute. In terms of international law, we call this jus cogens. Proportionality does not apply in the case of jus cogens. A right that is not absolute, that is not jus cogens, you can limit it, okay? You can say this applies, but I can make some exceptions. I can limit it, okay? There is freedom of expression, but you shouldn't disseminate racist information or make racist comments. This is a reason that limits the right, okay? So, and how do we assess this? Proportionality is the tool that allows us to put the line here, here, okay, on the basis of what is necessary. Had the court said, you know something, I will never apply proportionality to non-discrimination, it would have implied that non-discrimination is jus cogens. Do you think that... So, the European Court of Human Rights applies proportionality. This means that for the European Court of Human Rights, this is not jus cogens. This is not absolute. The Inter-American Court, we saw this last week, said non-discrimination is jus cogens. Who is right, who is wrong? Obviously Europe, but... Who is right, who is wrong? Is non-discrimination absolute for you?
No, there's certain instances where discrimination is sort of
Positive?
perceived to be allowed to take place.
Necessary or... Yeah.
Yeah, and not even in terms of sort of positive discrimination, but in terms of, for example, if it is
Good point,
voting
good point.
rights in a state. The fact that you are a resident in a state does not mean that you have voting rights. So you will be discriminated against when people go to polls. You're not allowed to vote. Same as in prisons where children are not allowed to be in prison as adults. But there's a justification behind that.
Okay. Any excellent points. Any other points here? Is there anyone who says that non-discrimination is absolute, first of all? Let's start with this. That under no circumstances you would ever consider limiting or creating an exception. Guys,
say non-discrimination is by no means an absolute right. I'd be quite agree with Brian.
You'll say that the non-discrimination is by no means?
It's not jus cogens.
It's not jus cogens. Why?
Just examples of states sort of actively, in a way, discriminating against people.
Is this good then?
No, it's not good, but it's not practical. I say non-discrimination, it's not a viable option, it's not practical.
Mm-hmm.
It's not a possible way of doing it because there are certain rights that aren't asserted by that very means they are discriminatory.
But if the argument is that states continue to discriminate, I don't agree with this, it is not the right thing, but this is what is happening, it's not the argument I'm looking for. If you say that it is jus cogens, you say that irrespective of whether the United States have a death penalty, this should not be allowed, this is absolute. So, is there anyone here who thinks that it should be the case, so non-discrimination should be absolute?
No.
No. Then why is the Inter-American Court saying it is absolute, with due respect to Latin Americans? No, Latin Americans. Sorry. So, yeah, Latin Americans and Latin Americans. Yeah.
I think the reason that the Inter-American Court said that is just to try to control in certain way the acts that the United States is doing, because otherwise the United States don't care. They don't care anyway. But
so we say nonsense thing just in order to apply some pressure.
No, it's not like nonsense things. It's trying to protect. I think. That's quite complicated. I think they are trying to protect all the Latin American community.
It's the undocumented work as well.
Mm-hmm.
Yes.
Yeah, but they could do it in a technically sound way. Let me give you examples of discrimination that you will all agree that is good, okay? So, discrimination is part of the principle of equality. We will discuss in 3 weeks' time, I think, 2 or 3 weeks' time, what is equality. But equality means that you treat equals equally and unequals unequally, okay? The basis for the second is positive discrimination, okay? What is positive discrimination? When I give something more to a social group because it is vulnerable, because it is underrepresented, okay? So you have the idea of quotas. In some universities in the United States, there is a quota, there is a minimum number of students who are black or Mexican, Latinos, etc., etc. This is discrimination in favor of those people.
In Brazil, we have many quotas.
Okay, but then you go and tell to the president of the Inter-American Court of Human Rights, who was a Brazilian judge, that if non-discrimination is jus cogens, then this is not only illegal, but null and void. It does not exist. Jus cogens is a powerful tool. And I told you the very first time we discussed this when we discussed torture, that it has a cost. It means that under no circumstances I will make a discount to human rights protection. We need to use it cautiously. Otherwise, either we have something, we alter the meaning of jus cogens, or we make it inoperative. Why? Because by inflating, by saying, yes, jus cogens is important, let's make them all jus cogens. It doesn't work then in practice. So the European Court of Human Rights, to my understanding, is very right to say, well, prima facie, at first glance, there is an issue here. Let's see if there are reasons that justify this. Okay? I have talked with at least 3 judges in the Vallanatos case. Okay? And what they all told me, one of them is the Greek judge, the other 2 are 3 actually, Portuguese, yeah, anyway, 3 more judges. What they told me is that it was an easy case because the Greek government, the reasons they presented were simply ridiculous, non-weight enough, okay? So for the court, it was very easy to say, yeah, how do you protect children by doing this? By recognizing, the right of two people to have certain legal consequences with their wedding. Adoption was not an issue in this case, okay? So the justifications given by the Greek government were irrelevant and very easy to dismiss by the court, okay? So the court applied proportionality and said, well, those reasons are not good enough. You cannot say black people go there, white people go there. There is no reason, there is no justification for this, okay? And it concluded that indeed there is a violation in the sense that the Greek law is incompatible with the European Convention of Human Rights. What should the Greek government do to remedy the problem?
Allow same-sex couples to engage in sexual.
Sorry?
Allow same-sex couples to.
Allow same-sex couples. So, this is the law. What you say is level it up and make it applicable to all citizens. Okay? Other ideas?
I was thinking about it, and firstly, you have to identify whether non-discrimination is a liberty right or a equality right. Is in the first category or in the second category? Because I think sometimes it's just in this case, from my point of view, I think the state just doesn't have to specify who can access to a civil union. So it's kind of hands off of the state. Just establish a figure. And so whoever who wants to get a civil union can do it. But also, I think there are some points when a state has to protect someone for not being discriminated. So I think I wrote that in my opinion. Like, I'm kind of confused. Like, how do you classify non-discrimination? Is it in the first category or is it in the second category?
I'll come back to that. I haven't read your note, but this is a point I have in my notes to discuss with you. Before that, I'm just asking you for public policy advice here. So we have a judgment. It is against Greece. The court has found a violation. I want you to tell me what Greece needs to do in order to remedy the problem. I had one solution. Other solutions?
Demolish the law.
Demolish the law. So, no, what you suggest is civil union for everyone. What he suggests is civil union for no one. Leveling down. Are there any other solutions, and which one would you opt for?
You also make another law that applies to same-sex that was kind of.
This is the technicalities. You can amend the existing law, you can create a new law, you can, its legal system will find a way to do it. But what is the policy? What is the goal here? Leveling up or leveling down?
Leveling up, because the government has a duty to protect the citizens from interference and enjoyment of the right by third parties. So
okay, leveling up because of protection, positive strand. This refers to what you said.
Yeah.
Other answers. I want to gather answers.
I'd also level up, but from more to do with the practicalities of if you remove the law, what about those civil unions that you've already established or already given that
That's
right
a very good point. Let's leave it aside for the moment, in the sense that you could say that you have a transitional period of 2 years, 3 years, to either move to another box, marriage, or to return to your status quo ante, that is, okay? But yes, there are complications here, okay? But let's leave this aside for the moment, because I want us to focus on, this is a good exercise to understand positive and negative action. This is why we're doing this. Other ones?
Review legislation.
Review
legislation.
Yeah, repeal it. But yes, would you give, on the basis of that judgment, the right to everyone, or you would take it from everyone? Guys, yeah.
But if you take it from everyone, isn't that also an interference?
It is.
Isn't that also an interference with
To do what?
with their rights?
To
Repeal the legislation. Isn't that an interference?
If it is an interference, this goes back to the positive. Then all states that do not provide civil partnership, they are in breach of the convention. Okay, let's make things simple. Okay, very simple. Next week I get into that door, okay, to start the seminar, and I have a box with chocolates. Okay. And I say, well, I'll give a chocolate to every girl in the room because I like girls. Boys, I'm sorry, no chocolate for you. Okay? Is this discrimination? No, why? Because you will get the chocolate.
Because you like girls.
It is in an individual context, but imagine this was the state. The state says, I will give a benefit, I will give a right only to girls, but not to boys. Is this discrimination on the basis of sex, yes or no? Yes. Okay? So, boys complain next week and they say, we know something, what you're doing is not fair. Why? Because we should also, you should not exclude us, you should not discriminate. Next time I come here, do I have a duty to give a chocolate to everyone? Or I can simply enough not give a chocolate, to no one.
Are you the state now?
Yeah, I'm always the state in Israel.
Then you have a duty. You have a duty to balance it out.
Okay, I have a duty to give a chocolate to everyone. Any other arguments?
I don't think you have a duty to give a chocolate to everyone. You just kind of stop doing it.
She just wants 2 chocolates.
Yeah, no, in this example, you have a duty to take away the chocolate from the girls. So that is repealing the law is taking away.
I have a duty to take the chocolate from the girls. I agree with you. Okay, more accurate. So, do I have a duty to take the chocolate from the girls, or do I have the duty to give a chocolate to everyone? That's the question here. Leveling down or leveling up? Chocolate for no one or chocolate for everyone? Not what you would wish. I know you would all wish to have a chocolate. But as a matter of law, as a matter of legal duty, I'm not allowed to discriminate. This is what the court says. Does that mean that I have to provide the chocolate to give positive to everyone? Or it means that I should abstain from discriminating by simply enough not giving anything to anyone?
But if you already gave it, can't you just take it away like with no
This was his point. You have already taken it, they have started eating it, you cannot take it from their mouth. And I say, yes, this is a good point, but let's simplify things. Let's imagine I can't take it.
I don't really agree with what I say right now, but like in both ways, even if I'm great or I'm great, both reach kind of equality.
Okay, yeah. Yes. So, would it be non-discriminatory? This is unacceptable, because this discriminates. This is chocolate for girls, not chocolate for boys. One option is to give chocolate to everyone. One chocolate is to keep the chocolates for myself. Okay? Are they both compatible with non-discrimination? Yes?
But if you as a state have some additional resources to buy more chocolates, then you have a duty to buy more chocolates and give them to the boys.
Says who?
Well, if you that's the duty.
If I have more resources to get more chocolates, I keep it for myself.
No, so you buy them and then you make sure that the boys don't go hungry.
You're a communist.
But if you don't have the resources, then you're not obliged.
I need legal argumentation.
Yeah,
You gave it before, not in this before, when you talked about positive and negative. This is where the answer is, and this is one of the reasons why we are doing this exercise, and this is why I was telling you that this distinction between positive and negative obligations is very important. And I told you that every time you have a human rights question, the first thing you ask is this positive or negative? Why? Because it changes the scope. It changes what we expect from the state. And it also changes the legal tools we employ. Because negative is obligation of result. You only apply proportionality. Positive is an obligation of means. Apart from proportionality, you also examine whether the state had the means, had the money to buy the chocolate. Okay? So, other ideas. Legal justification.
Isn't that the benefit? So
It's no doubt of the benefit. No, it's everything is very concrete here. It's crystal clear.
So this is negative obligation.
I don't know, I'm asking.
I think it's negative because negative is when they state.
If I would ask you to put here negative and positive, where would you put it? Leveling up would be negative or positive?
Positive.
No, negative.
Negative or positive?
Positive.
You're lost.
Positive.
Are you lost?
Positive.
Yes? You're lost.
I didn't think so, but maybe yeah.
Okay, a step back, okay? Week 2, or week 3, I don't remember. Week 3 actually. We said that all human rights, and this is an answer to, stop texting now.
Oh, sorry.
This is an answer to your question. I told you that all human rights develop a negative, a positive, and fulfillment. This is protection, we call it protection. This we call it respect. That's the jargon we use. Respect means negative, protection means positive, and then we have a third category, fulfillment. Let's leave it aside, we will see it in more detail in 2 or 3 weeks. Negative, in simple terms, means hands off. Okay? I'm saying this way so that you remember it. Hands off means do not discriminate. Do not get into my house. This is why it is a negative. Do not. Do not kill me. Do not torture me. Positive means provide, give. Give chocolate. In my example, the negative would be do not discriminate by giving chocolate to some people and to some other no. Okay? The positive duty would be you have a duty every time you come here to give a chocolate to everyone. I don't, trust me. Okay? And if your argument is the money I have, then if I get more money, what? I'll give you a sandwich and then a Coke and then, it's endless. Okay? So, negative is obligation of result. This is obligation of means. This means you do the best you can do. Were you in section 3 here? The example with the doctor I gave, okay? So, is this a case, Valianatos, is this a case of a good doctor, or is this a case of someone who breaches a negative obligation? This is the question.
I think it's negative.
You think it's negative? Okay, who else says negative? Just raise your hands.
I think that it was originally ruling on a negative issue, but in order to remedy it, it's creating a positive obligation.
Why?
Well, the negative was that they're saying you haven't respected the principle of non-discrimination because you should have interfered with same-sex couples.
So
if you hadn't have taken any action,
I interfered and I'll remedy the problem.
And the remedy is a positive obligation.
You can, if you want, you can do it. No one will tell you no. But as a matter of law, you don't have this obligation. Why? Because you have to remedy the problem that was found. If a negative problem was found, then you have a duty to remove this negative dimension. If a positive was found, then you have a duty to provide, to give. So in my example, I'm coming here and I'm giving chocolate to the ladies, okay? And the coach says to me, what are you doing here? You cannot discriminate on the basis of sex. And the question is, I can go back and say, can I have back the chocolate? Yes. I gave no chocolate, no one ate the chocolate, we are happy. So, is it a negative or a positive? Or does the court tell me, you need now, you gave to the ladies, make sure now you give to everyone?
I believe
Negative.
I still think it's negative.
Negative. Negative or positive?
I think it's positive.
Positive.
I think it's positive.
Positive. Okay, before that, this is the problematic law. Leveling up. Is it positive or negative? I give chocolate to everyone. I give, I provide.
Positive.
Positive. This is positive. I give no one nothing. This is negative or positive? Negative. So you have a judgment against the country, and the country then needs to comply. Leveling up amounts to compliance with a positive breach. Leveling down amounts to compliance with a negative breach. Okay. What was this case about? Negative or positive? It's too tall, too high for me. Negative or positive? Hmm?
Positive.
The answer is in the judgment. This is what they complained about. The applicants complained that the fact that Vasilis gave chocolate only to girls infringed the right to respect for the right to chocolate, taken into account with the right of non-discrimination. Did they complain for a negative breach or a positive breach? Negative.
So it actually says later on, I think paragraph 75, it says the complaint is not that the Greek state failed to comply with any positive obligation, but that it introduced a distinction.
Okay. So those guys, the applicants, they didn't go complaining and saying, well, everyone should have the right to civil union. Everyone should have the right to have a chocolate at the beginning of the seminar. What they said is that if Vasilis wants to give a chocolate, if the Greek state wishes to give civil union, it cannot do it only for boys, it has to do it for girls too, or vice versa, or different same-sex couples. Clear? So, the answer is, as a matter of law, the advice I would give, and actually I gave, but they didn't listen to me, to the Greek state is that if you want, you can level it up. It's up to you. But don't think that the European Court of Human Rights, with this judgment, is obliging you to go up. You can simply not go back. You can go to the situation before 2008. Okay? This is against my ideology. I think it is a matter of equality and I wouldn't apply this method of interpretation. But as a lawyer, this is what the law said, the court said, and this is how I understand it and how I interpret it. Sorry, acknowledging the problem that in the meantime there have been couples that used this, so there was...
Wouldn't that be like an interference of their family rights?
Yes.
Because they might
we made this point too, and we said that a transitional period could be given, etc. So this was a fantastic point. Yeah.
So I sort of see a duty. There's a duty in that case or in that judgment under Article 8 to a hands-off duty, and I saw, when I read the judgment, I saw sort of two different obligations there. On the one hand, there was Article 8 on the respect for private and family life, which is clearly, if there's a right to respect of private and family life, the state should keep its hands off.
Mhm.
Don't interfere with that.
Mhm.
So that's on the one hand. Then on the second hand, there was another obligation under Article 14 on prohibition of
And you
discrimination.
say that this was a positive one.
So this is where the state is supposed to step in and enable through legislation.
Non-discrimination, I'm a bit behind schedule, and so non-discrimination has both a negative and a positive dimension. In that particular judgment, the complaint by the applicants was about the negative dimension. So the court didn't make the extra step. The court said, you asked me if this is, if you can give chocolate to some people and not to others. And I'm telling you no. You did not ask me if the state has a duty to provide civil partnership to everyone. This came something like a year later on. There is another judgment, Oliarti versus Italy. And in that case, the court made the extra step and said, now there is a positive obligation. And now all states in Europe have a duty to enact civil union that would be recognize the legal status of same-sex people. Okay? But in that particular case, it was a negative one. Okay? Two more questions. Why do you think the lawyers, I happen to know the lawyers too, in that case, and I don't like them, obviously. They are not good people. But the lawyers in that case, why you think they went with a negative claim and not a positive one? Why they said Vasilis should not discriminate by giving chocolate only to girls and not to boys, and not the opposite? Why did they say Vasilis has a duty to give chocolates to everyone? Why you think they did that? Start thinking now as a lawyer. What you want to do to win your case. Why they thought they had more chances to win their case if they limited their claim to the negative one.
It would just be genuinely harder to prove that there is a duty.
Why? It's the right answer, but why? We discussed it earlier. I showed you the paragraph and I asked you to read it. Because the majority of states in Europe do not think yet, do not have a domestic practice that says every time you get in the room you give chocolates to everyone. Because the majority of states in Europe do not provide for civil partnership for everyone. Okay? I'll raise this question now and we'll discuss it next week. Part of it, but just to make the following point. So one of the things we will discuss this week, we started discussing it this week, is whether human rights should be interpreted on the basis of principles, equality, values, etc., or should be based on the basis of evolution coming from states, public opinion, etc., etc. Okay? The European Court of Human Rights, in that type of cases, is obviously following the latter path. So it says, states are doing this, I will follow the tempo given by states. Okay? If you follow the tempo given by states, and this is the situation right now in Europe, states do not want to give marriage to same-sex people, but they want to give them same-sex partnership. So states, if we ignore the principle, it is fine, it is non-discrimination to say that two people of the same sex will be excluded from marriage, but it is not acceptable that they will be excluded from same-sex partnership. Does it sound right to you? Isn't it double standards? Is it discrimination? My question in very simple terms is it fine to say that same-sex couples should not be excluded from same-sex partnership, civil partnership, but it is fine to say that they are not having the right to marry? Marriage. Civil union. Okay? Two different legal boxes. Do you all know what marriage is? Do you all know what civil union is? Yes? Okay. The European Court of Human Rights, because of following morality of people, public opinion, etc., it has said, this is for everyone. Or this is definitely for same-sex people. This is only for heterosexuals. Is this fine? Yes?
It's still unequal, because it's not like you're giving one to same sex and one to...
But public opinion is fine with this, and so the state practice of in Europe.
Yeah, still unequal.
Still unequal.
Yeah.
So you would go for values.
Yeah.
Okay?
Do you
A
think?
dictator. I'll explain you next week.
Do you think we have to apply proportionality in order to understand what our...
No, it's not a question of proportionality here. Any other dictators? The problem here is the legitimacy of judges. You have 17 judges in Strasbourg sitting in the Grand Chamber. Can they dictators dictate the moral standards across Europe?
No.
47 states from the UK and Ireland to Azerbaijan?
No, they can't. But it is unequal.
It is unequal, definitely. And you're having... So, who says that this is fine? For everyone? Or it's even worse. This is where the BBC thing comes. In the UK, very recently said, this is for gay, so same sex, different sex. Some countries say different sex, and this is for both same sex and different sex. These are pretty much the same. Do you see any problems of equality here?
In cases where it is, like in the UK, different sex versus same sex, it reminds me of when in America was the rules of separate but equal. And on face value, yes, they are equal, but they're not. There are still some fundamental differences.
It is exactly what it is, and again in this note we wrote for the government, we wrote also this. This is separate but equal. Do you know what was happening in the United States in the 60s? Huh?
The Kinsey report, the Kinsey report or something.
Brown diversification.
Jim Crow laws.
The story was very simple terms. The American government was saying, I'm not discriminating. They are paying the same fee. The bus leaves at the same time and arrives at the same time. It's only that there is one bus for black people and one bus for white people. You have the same rights. It's separate but equal. It's apartheid. This is what Europe is currently doing. And this is because they follow what states want and public opinion, etc. It's separate but equal. It's exactly the same thing. Any questions with regard to that? And then we move to an entirely different topic. Connected with the Hughes Coggins thing we discussed earlier, but different. Any questions? Any? No? Okay. Germany versus Italy. Less sexy topic. What happened in that case?
The question of immunity, wasn't it?
Immunity, yeah.
Germany was claiming that Italy was not respecting its sort of promises.
Why?
Because of the crimes committed in the 40s.
In World War II?
Yeah.
Mm-hmm.
Just find it.
Italy allowed claimants to bring proceedings
Okay.
in their courts against the German armed forces for the acts of the German army, and Germany alleged violation of jurisdictional immunity.
Okay, what is jurisdictional immunity? So, this is Germany. This is Italy. In World War II, Germany committed crimes, war crimes, for our purposes, let's call them human rights violations, in Italy, okay? And then Italy did what?
Italy allowed proceedings. They said that the Italian claimants brought proceedings in Italy and they were enforceable.
Okay. This was part of it, yes. Another part was that it exercised jurisdiction. What was the problem with that? First of all, what is sovereign immunity or jurisdictional immunity in particular? Guys, eye contact. Look at me, everyone. I know Apple is much more interesting, but look at me now. Germany, Italy. Germany committed in World War II crimes in Italy. Okay. What is immunity? What is immunity under public international law? Yes.
They can't be prosecuted.
They can't be prosecuted. They cannot. So one state cannot prosecute, try both criminal law and civil law. Okay. The organs, the sovereign organs, or the state itself before its national courts. Why? Immunity means that a diplomat here from China, no. So the Chinese ambassador here cannot be tried by British courts. And if China does something against me, I cannot make a claim before British courts against China to get a compensation. Why?
It's a standing.
Why? Yes.
Because it's territorial, you can't prosecute one country in your own country.
Why? This is what it is. Why?
Is it because it has to be with the idea of international law where states are sovereign and so they were
sovereign and what more? Sovereign?
Unequal.
Sovereign equality. Yeah. So international law says we are both states. We are both sovereign, and sovereignty means that Germany cannot be under the authority of Italy. And we are equal, which means that you have no more sovereignty than me. Okay, so immunities is a very old law in international law. It has several dimensions, functional. Anyways, read the textbook. It's a different topic. We could have discussed this in the first semester. That immunity is a very old set of rules in international law, reflecting, deriving from sovereign equality. Both states are equal. So Germany, as a sovereign entity, cannot be tried by the courts of Italy. Italian courts do not have any kind of power, any kind of authority versus Germany. What did Italy do in that case?
They allowed civil claims to be brought against.
Okay, so you had Italians who went before Italian courts and they sued Germany. And Italian courts said, well, Germany, you shouldn't have breached human rights in World War II. Now you need to pay compensations, you need to pay reparations. Germany said, I don't care. Why? We are equal. Hello, I'm Germany. I'm not your citizen. I'm not under your authority. I'm at the same ranking as you, and your courts have no competence over me. And Italy said, well, I don't care. I will still comply, execute the judgments of my national courts, and they wanted to confiscate German property in Italy. So the German state had property in Italy, in Florence, and they wanted to confiscate it and give it to the people who lost family in World War II. Okay. What was the argument, the legal argument on the basis of which Italy allowed this to happen? Who has read this case?
Well, Italy's first argument.
Apart from you two, who has read the case? 3. Guys, it's so disappointing, really. I'm not. I'm talking at a personal level here. It's so disappointing. I mean, the whole purpose is that we discuss these things here. Another argument: you're paying for this, and you're paying lots of money for me to be here for 2 hours. Not that I'm getting the money you're paying, but it's another issue. And I'm here to discuss these cases with you too. Anyways, what was the argument by Italy?
Isn't it, not international, but in domestic Italian law, you know,
It was it was absolutely. You can have the strictest rules you want. They cannot go against international law, otherwise you will be internationally responsible. Italy made an argument on the basis of international law, and especially international human rights law.
In this case, should based on the public acts or the private acts by the German?
This is the distinction you have in immunities, and you distinguish if it is the state is acting as a private actor or as a public authority, and this is a criteria to establish whether immunity applies. But immunities do apply in this. Italy made a different argument. What was the argument?
That the acts that were committed was serious violations of international law, and that they also constituted
Jus cogens. So Italy said, Germany said, immunity. Germany said, I am immune, okay? You cannot touch me. And Italy said, yes, I can. Why? Because you violated jus cogens. Who is right, who is wrong?
Well, it's a violation of your scope, and then Italy's right.
What did the court say, first of all?
There is no conflict between the rule of rules of jus cogens and the rule of customary law, which requires one state to accord immunity to another.
Okay, yes, so Italy was saying there is a class between those two, and the court said no class. Can you elaborate on your argument?
Yeah, jus cogens is because it's the Prince of Rome. Its authority is over the state. So if under state Germany breaches a rule of jus cogens, then it can be enforced by another state. And so that's why Italy is saying, well, because it's jus cogens, we can prosecute you. It's not a matter of being equal, it's a matter of being above you.
This is the argument by Italy. Why you agree with it?
Well, I agree with it because I stand by jus cogens, the principles of jus cogens in certain aspects.
So for you, jus cogens should have that effect as well. Do you agree with this point, or do you agree with the argument by Italy?
I would be inclined to agree with the court that argued that immunity is a procedural matter, and jus cogens, it's not a question of were the actions right or wrong. It's just a question of can they bring a case?
Mm-hmm.
And that's what the court argued throughout. They said, you know, what Germany did was absolutely awful. We're not disputing that, but this is purely a procedural question of can we bring it? And basically immunity trumped that because it wasn't trying to argue with.
This is exactly what the court said. Anyone who agrees with the court or with you?
Yeah, I think so.
You would agree with the court? So let's see how many Germans we have in this.
I think I'll go for the jus cogens. So I'll be thinking.
You would go for, of course, you're Latin American, you're a kid of Cansado Trindade. That's the same line of reasoning here. This is the point I'm trying to make. Yeah? Why you would go for the jus cogens?
I think, I don't know yet, but I think that humanization of international law is actually happening. So I think it's a reflection of it. Like even though you have general principles like immunity, you do have also this lex specialis, but also create that kind of, other level in the hierarchy that actually it's affecting general international law. So that kind of just coachings go into the immunity.
Okay, good point. What is the reason behind immunity? I already told you. Sovereignty. What is behind jus cogens? Human rights. If we move to a next level of abstraction, the dispute between Germany and Italy is not only a dispute between immunities versus jus cogens, where you've heard both arguments, I will repeat them later on, but in reality a clash between an old approach to international law, the old international law before human rights, where everything was a matter of sovereignty, states were the absolute rulers in international law, versus a new, modern approach to international law, which is increasingly humanized. And human rights are weighty enough to trump even old established rules of international law, such as immunity. In reality, behind that case, you have a battle between two different approaches in international law. The old school way of thinking, which is in favor of sovereignty and statehood. This is state is with a capital S is the most important, and the other one who says no, state shouldn't. International law is not primarily about states. It is about human rights. And when states do something that goes against human rights should trump other considerations, other rules. Which of the two you would favor? Who is a state person? State person? You're all human rights people here? Any human rights people?
Humanize human individual, yeah. Not the
I mean, yeah, but you can translate that battle. So this is a theoretical. So in theory, you have scholars who write in favor of this approach, and other scholars who write in favor of this. And this then also translates into, we will come back to whether there is a conflict of rules or not, but into a conflict between state rights versus human rights. So I'm asking you to see this dilemma in the context also of this specific case. Because going back to Cansado Trindade and to the non-discrimination thing, it is very easy. You sit somewhere, you're a judge and say, yeah, human rights are so good, they should, give priority, let people be happy, On the other hand, real life brings this into conflict with other rules. And this is when you need to get more pragmatic. So, who is more in favor of human rights is who is in favor of sovereignty and states. States, anyone in favor of states?
I'd say on this question.
On this question, states? Yes? States?
It's not possible to make everyone happy at the same time.
In law, definitely not. You have to make a decision.
Yeah.
But and decisions are always, we're coming from somewhere, so there is an ideology behind our decisions.
But also from the reading, there was a theoretical reconciliation approach.
Mhm.
To try to measure when to apply human rights before general international law and when to apply. No?
No. Quite the opposite, I would say. I'll explain you later on in more detail what the code said. But so, who is in favor of sovereignty and who is in favor of human rights? State people. So, why state?
I think on this particular question anyway, sovereignty is quite important because of the nature we're talking about. Can one state try another state? And I think that's fundamentally wrong. And I think sovereignty is quite important.
Even if it is for the most serious crimes.
I think absolutely, because where do you draw a line? You know, does it sort of set precedent, or at least an influential?
So for you, immunity is absolute. Immunity is jus cogens.
Not necessarily. I don't know. I just think in this particular, if you just look at it as a kind of try and strip morality from it, and you just look at it from a procedural standpoint, I think.
Okay.
Should have trumped.
Any other state? Your state?
Yeah.
Why?
I don't know, just like when you have a court in Italy, like the side is a citizen, that side is a country, so states, how can we equal? And descendants from Italy, how can they just like go to Germany? What happened? And like
In the same way that Germany 60 years ago went to Italy and was killing people.
But when you say if has international criminal things happen, there is no sovereignty things, no equal things, there's use Collins concept. I don't think it makes sense for like.
Okay. Your state, aren't you? Ambivalent. Any arguments? No? Just a preference.
I don't know, I'm thinking about something like diplomatic protection, something.
Diplomatic protection would be the alternative, and this is what existed in international law. But if you don't follow that path, so this is a good point. The point here is, instead of going against immunity, what you could have done is make it an international dispute. And Italy would protect its citizens. Diplomatic protection means that a dispute between Italian citizens and German citizens becomes a dispute between Germany versus Italy. But let's think in pragmatic terms. How would that work? The ICJ only has competence if you have recognized the competence. Germany never recognized competence of the ICJ for anything that has to do with World War II things. Okay? For good reasons. What would you do? Countermeasures? They're partners in the European Union. What would you do? I'm not making trade with you because 70 years ago you killed my people? So this was another path. Lawyers tried to find another path to hold Germany accountable. And because they couldn't do it by the means of international law, they did it by the means of domestic law. And Germany told them, yes, but international law doesn't allow you to do this. Let me give you again the bigger picture here. So this is a symptom of, I would call it an identity anxiety of international law, okay? Do you remember who was here in the very, very first seminar? Or who was not here in the very first seminar? You were not here, 3 of you? Okay, what I was telling in the very first seminar, was I was giving the example of Spider-Man, okay? Do you remember the example of Spider-Man? Yes? No? I'm giving so much thought to bring you some interesting arguments and then you just throw it to the bin. Do you know what Spider-Man is? All of you? Yes? Yes? Everyone? So, it is a human who is bitten by a spider and then the DNA changes. And I was telling you that international law, this is international law, until World War II, until human rights, was like Mr. Spider-Man before being bitten by the spider. And then, all of a sudden, after World War II, you introduce into that system human rights, okay? And this changes the DNA, this changes the structure of international law. Why? Because initially it was a system just between states. And now you're introducing Italian citizens, okay? You're introducing a new player into the DNA, into the system, okay? And this means that international law had to change. Jus cogens is such a change. Erga omnes obligations and collective enforcement that we discussed in the first semester, that the idea that if someone breaks values that are common, then all states should be allowed to enforce the law and react, is such a reaction. The fact that we have individuals as subjects of international law is such a change, okay? So, what is the whole thing about the humanization of international law? And the symptom of that humanization is this judgment. You have Mr. Spider-Man. Imagine of him sitting at, on the roof of a building at 2 o'clock in the morning, okay? And he's thinking and saying, well, am I now more of a spider or I am more of a human being? This is an identity crisis. Those people are saying that, no, you're a spider. Human rights. Human rights prevail. Human rights are inside you. You cannot ignore it. You cannot close your eyes. And when they take the argument to the next level, they say, you know something? Human rights are constitutional international law. You have this theory, I gave you to read my paper, no one did. The constitutionalization of international law, which says that because of things, you did, I know, after, with a week of delay, you have it there. So constitutionalization says that human rights are so important, so fundamental, that they have acquired the status of a superior, they have acquired the superior status in international law. And the rest goes back. So, humanization, the theory of the humanization of international law says that international law is changing its DNA because of human rights. And the theory of the constitutionalization of international law says that not only it is changing, but that human rights are on the top. Okay? And then you have the old approach, you have the other side, the other half of Mr. Spider-Man who says, no, I'm still a human being, look at me. Everything is about states. We still have immunity, we still have sovereignty. And the two of them are in a battle inside that system. Do you understand what I mean here? Can you give me of other examples outside that case? Again, it was on my other paper, on the humanization of international law that you had for this week. Other areas where human rights have attempted to change international law. Any other areas? Guys, any other areas? Any other examples? Any other? There is a book that I gave you to read the introduction of the book. Did you read that introduction?
Oh, yeah.
This makes a summary of this book has, each chapter is an area that has changed, allegedly, because of human rights. Reservations to treaties.
Also diplomatic protection.
Diplomatic protection.
Consular notification.
Consular notification.
State responsibility.
State responsibility, definitely because of Article 48 erga omnes. The making of custom. In your semester 1 question, this was part of it, okay? Custom is changing, why we have a new custom? We don't care about state practice, the same discussion we had earlier. Non-discrimination of Mr. Valianatos, we shouldn't check what Lithuania is doing. We don't care about it. We don't care about state practice. Why? Human rights should not be an issue of state practice. Reservations to treaties. So, in a nutshell, because of human rights, because of introducing human rights in the body of international law, international law, according to some scholars, is changing. And they give a number of examples. They say, look at your head. It's not anymore the head of a human being. You have big ears. Look at your hands. Now you can throw these things over there. Look at diplomatic protection. It wasn't like that 50 years ago. Look at state responsibility. It wasn't like that. You're no more the same Mr. Spider-Man. And then constitutional theory says not only that, but your brain, the cornerstone of the system, now is human rights. And this is what allows Italy to say, well, immunity. I don't care. Why? Human rights is more important. It's jus cogens. What is my argument as a scholar in all those? What have I said in my papers?
What is your argument for what?
For the constitutionalization, the humanization of international law.
I haven't talked about, so I don't know if I actually got the full argument.
Should I tell you or should leave it? I leave you to read it. Tell or punish you and let you read it if you ever read it. If you don't read it, you will remain ignorant for the rest of your life. Should I tell you?
Yeah.
Yes? Let's have a poll. Who says tell you?
Yeah.
Get it over with.
Yeah. My approach on this dilemma is that yes, human rights exist. Yes, human rights have brought changes to international law, but we still have that struggle. And there are human rights lawyers who are pushing the agenda for human rights, but on the other hand, the law is still made by states. And in my paper for this week, I'm giving a number of examples of areas where you had this idea of changing because of human rights, but in reality then the ILC, courts, states, state practice made the step back and said, yes, human rights is important, but custom will still be the same. Yes, human rights is important, but diplomatic protection will not change. Yes, human rights is important, but still immunity is here. And this is what the court says in that case. In that case, one of the methods of reasoning, one of the lines of reasoning of the court, it says immunity. Let's see state practice. Has immunity changed? How many states did the same thing that Italy did? Well, it's only Italy and a couple of other states. The majority of states,
Remaining the idea of immunity.
they give priority to immunity. So I cannot go against it. If you states you change, then human rights will also find more space. But states are still the key holders. So on the one hand, my argument is that the whole humanization thing is inflated. A complementary argument to that, this was in the paper in previous week, is that we are talking about the constitutionalization of international law. There is no such a thing as a constitution. If we want to use this as an analogy, like some rules that are more important, then international law had for centuries contained some important rules. Constitutional, it is a system, its features, systemic features, are it is sovereign, based on sovereignty, equality, reciprocity, self-help. This is the old international law. And this was also a constitutional setup. So don't talk about constitutionalization. You can talk maybe about an implicit reform of the constitution, but that if this is constitution, this has always been the constitution of international. On the other hand, yes, international has changed because of jus cogens, erga omnes, and due diligence for me. Due diligence is the principle behind positive human rights obligations. Erga omnes is collective enforcement, and jus cogens is the idea of hierarchy. Okay? And these are important shifts in the system of international law. So, any questions? No?
I just wanted to ask if there has been any abuse of that sort of state immunity. For example, if a state A goes into a state B and commits acts that are going to advantage state A in the state B and claims immunity, but at the same time, these acts were violations of human rights of a serious nature. Have there been any acts of such nature?
Plenty of cases, okay? I can give you case law from the European Court of Human Rights, which exactly, even though it is a human rights court, it said immunity. And if you read the ICJ judgment in detail, you will see that it has a part where it is discussing a number of examples coming from the European Court of Human Rights, domestic courts, Spain, the UK. So this started actually with some cases against former dictators. Okay, so you had the Chilean dictator, and the idea was, could he be tried in Spain or in the UK? The dictator would say, immunity. You're a foreign country, a foreign forum, you don't have any powers over me. And you had this battle, human rights versus immunity. So the court, the first thing, one of the things it did was to check, is immunity still robust in international law as a rule? Or state practice has changed? And it said, no, state practice is still in favor of immunity. And the second argument said, okay, hold on guys, yes, some of human rights are jus cogens, and war crimes are jus cogens. Okay, so Germany breached jus cogens. What does it mean, jus cogens? Can you give me a definition of jus cogens? What is jus cogens?
Oh, nobody can define it. Nobody can define it particularly well.
We have a problem with
how to create.
We have a problem with regard to the recognition. To say this rule, this particular rule, is jus cogens, and this is done by judges ex cathedra. This is what we said last week, or by the ILC. But as soon as a judge tells us this is jus cogens, like in this case, they said war crimes is jus cogens. As lawyers, we know what are the effects, the consequences.
There are peremptory norms from which there can be no derogation.
So, peremptory, no derogation is one effect. So, no derogation. I would add exception, no derogation, no exception, no limitation. Can you translate this argument in simple terms? What this means?
There's an obligation on the states to not do anything in contravention to these rules and to abide by them and to ensure that...
Yes, something more than that?
It's a rule which doesn't apply proportionality.
No proportionality. This is the discussion we had earlier. If you start applying proportionality, then it is not jus cogens. Jus cogens means absolute, okay? One is absolute. And this is the constitutional dimension of it. So no proportionality, no limitation for whatever reason. Second,
a characteristic of jus cogens is that it is accepted and recognized by the international community.
No, effects, legal effects, legal consequences.
State responsibility.
In terms of state responsibility, what?
They're liable.
They are liable for any rule of international law that is breached. It's something more.
It could be enforced by anyone.
Yes, why?
Because it's a collective value.
Yes, so it is what more? All jus cogens rules are erga omnes. So, jus cogens means absolute, means erga omnes, and something more. Conflicting rules are null and void. Article 53 of the Vienna Convention. So, hierarchy. Leading to nullity. Okay? These are the three main features of... The first one is absolute. The second is erga omnes. And the third one is hierarchy, supremacy, and conflicting rules are null and void. Okay? Clear? Yes? So, try, it's like an equation. I'm not good at math, but replace these human rights, jus cogens, by those three effects. Is there a conflict with immunity? What immunity says? you don't have the right to exercise jurisdiction, to try me in your legal system. What does jus cogens as the prohibition of war crimes, so the right to life, mean? It means don't kill under no circumstances. Okay? Does it mean, does any of these, so jus cogens means this. Does any of this mean that you have the right to prosecute me? Is there an effect of jus cogens? Do you understand my point?
Yeah.
No, you don't. I see it in your eyes. Germany was saying, I'm immune, you don't have the right to exercise jurisdiction to try me in your domestic legal system. Italy was saying, yes I do, because you killed people, and this is jus cogens.
Can I ask a question? Is immunity, state immunity, is that also just jus cogens?
That's a good question. No court has ever said that, but
because if we're saying it's,
it's
trumps human rights, then that would be to me saying it's inviolable.
I wouldn't say that it is jus cogens because then all conflicting rules would be null and void, which is too harsh.
Okay.
And this is actually an argument against Italy, because if there is a clash between these two, then immunities should be null and void. If we take Italy's argument and we push it to the end, then immunities would not exist in international law. It's nonsense. But the main argument by the court was that there is no proper conflict. Why? Because jus cogens doesn't mean access to justice. The court didn't say it in this term, but what they implied is that the opposite of immunity is access to justice. And access to justice is not jus cogens. Jus cogens, yes, war crimes are jus cogens, the prohibition of war crimes, but jus cogens is not, doesn't have any magical dimensions. It means those three things. And those three things do not justify trumping immunity. So, very last point I want to make is that both the judgment we saw last week on the opinion on Mexican migrants and this case are both examples of what I call inflation of jus cogens. Jus cogens is a very strong tool. We need to use it cautiously. But human rights lawyers, they want to present everything as if it is jus cogens. Everything is jus cogens. Why? Because human rights is important. But then the consequences are here. Just to give you, do we have 2 more minutes?
Yep, there's no one outside.
Fantastic. Are you all happy to stay 2 more minutes? Just to give you a little bit the background of this story and to see how things get political, okay? Greece, my country, interfered in this case. Actually, the big dispute was not between Germany and Italy. The big dispute was between Germany versus Greece. Why? This whole thing started from Greek courts. So you had people who lost family in World War II, and they were lobbying the Greek government for a number of years to go against Germany. The Greek governments, for very obvious political reasons, especially now with the economic crisis, because Germany is feeding Greece, okay? Greece, for very obvious political reasons, did not want to make a dispute at the international level with Germany on this. So you have some, and this also raises very important theoretical issues. What is state will? Okay? State is not it's not a unitary simple thing. It's not a dictator. It's a democracy, and you have many players in the system. So those victims, seconded by some lawyers of dubious morality, etc., went before domestic courts and at the very local level, so low-rank courts. And obviously they knew the judges, and they tell you, okay, you do this, etc. And it costs nothing. It's populism in reality. Okay? Those people were elected then as MPs at the local level. So you see how politics is everywhere. It costs nothing. It costs absolutely nothing. Why? Because you have the Greek judge who says, yes, we Greeks, we are the victims, Germany should pay. And this is an example of how justice can interfere with foreign policy. And you have this big dilemma in a democracy. Should external relations be an issue of democracy, or all institutions, all judicial institutions, or only foreign ministers? These went until the highest level in terms of justice, so the highest court you can have in the Greek legal system. And there were also some interesting games there, because the decision, the highest court took a decision in favor of immunity. So the Greek courts took a decision in favor of immunity in the end. But again, this was very off the record, very politically, not very clear. Why? Because this was taken thanks to the vote of the president of the court. So there was a parity between the members of the court. And the member of the court was, he stood in chair. His term was prolonged for a small period of time so that he can preside in that case. By what I mean that there is always an interference from government, okay? And the court, in that judgment, so people could not execute, it's a bit complicated, but there is a big number of cases. Some of the cases in Greece by lower courts were in favor of the victims, and they couldn't execute them in Greece, so they went, because of EU law, to execute them in Italy. And then Italian judges said, look what Greeks are doing. They will get money. And they started following the same pattern. And then Germany said, okay, enough is enough, let's stop playing games. We'll go to the court and they will tell us if immunity prevails. So there are other dimensions as well, and many political dimensions, populism. After 80 years they wanted compensation. Okay, this is not a crime that took place yesterday. But another dimension I want you to remember, for the purpose of what we are doing, is, and you can see this in the judgment of the ICJ, is that states are not always a unitary thing. And the Greek court said in that case, the ICJ said in that case that Greece, because Greece intervened before the court in favor of Italy. And the court said, what are you doing here? Your national organs, your government and your highest court were against immunity. Decide, which side are you with, Euskogans or immunity? And this also has to do because there was a change of government in Greece, and the previous government was in favor of immunity, and the new government was in favor of Euskogans. So, bottom line, in international law we say state will makes the law, okay? It's very simplistic. What is state will? The government changes, the will change. Is it government or courts? Whose will? And this also has important dimensions for custom making. What practice accounts as customary practice? Is it the practice of the government, or is it the practice of courts? And what is it if there is a conflict, a contrast between government and judicial practice within a state? Okay? For next week, I'll give you 3 papers to read. The 2 of them are absolutely compulsory reading. The third one, I will tell you which one is if you want, which means you will not read it. But I give it to you because one of the essay questions will be relevant to what we are doing next week, and you might find it interesting. Okay, so, and then I will give you also 2 cases. Okay, but please do both the cases and the 2 papers I'm asking you to read. Okay? Register. Can someone